Hello, and welcome to today's webinar. I'm Nick Zulovich, part of the team at Cherokee Media Group, and pleased to welcome you to the session titled Real Talk on Refunds, Elevating Your Aftermarket Servicing. And it's all brought to you by our friends at Allied Solutions. A couple of quick items to go over before our experts take over. We are recording today's session, so keep watch of your inbox for a link to that recording so you can review the great material and share it with your teammates. You will be in listen-only mode for our session today, but you can use the chat function here on Zoom to ask questions that we'll address after the presentation. So without further ado, let's bring on our experts. Peter Krall, who is the Vice President of the National Market Group at Allied Solutions. Robert Christini, Senior Director of Lender Solution Sales at Cox Automotive. And Stephen McDaniel, Co-founder and CEO of F&I Sentinel. Gentlemen, take it away. Thank you so much for being with us today.
Hey, thanks so much, Nick. We really appreciate your time and consideration and support of the industry. We hope everyone finds this next 45 minutes or so very useful. We'll leave some time for Q&A at the end, and we've got a couple of questions throughout our session to hopefully kind of compel some thought and some action around things that we continue to see evolve when it comes to optional ancillary products and the product refund liability associated with those products sold by dealers. So really with me today, it's an honor to be with our partners at DealerTrack Cox Automotive with Robert Christini and Stephen McDaniel. I know you and I have had a busy week ourselves relative to some recent legislation out in California that passed that we'll touch upon. But definitely, I just wanted to give both Robert and Stephen a moment here too, Nick, to introduce themselves. Go ahead, Robert.
Awesome. Thank you, Peter. Excited to be a part of the webinar today, representing Cox Automotive and the great partnership we have with Allied Solutions. As you said, a lot of movement recently in the aftermarket product cancellation space. So excited to kind of present some options that our lenders have in the marketplace and, different findings we're seeing across the board with all the lenders that we're working with today. Hand it over to you, Stephen.
Thanks, Robert. Thanks, Peter. Appreciate you guys inviting us to join you today. Looking forward to walking through the various issues that most lenders are facing today in connection with product refunds. And as Robert and Peter and Nick both mentioned, we do quite a few developments that are occurring on a rapid pace. So I think we got a lot to dig in today. So appreciate you having us join and look forward to the content.
Great to work with you fine gentlemen. Yeah, we've had a couple of panels like this over the years, and again, appreciate everybody supporting this endeavor. And again, Cherokee Media, thank you for the opportunity. You guys have done a great job keeping these kinds of issues in front of our auto loan servicers. And we really start looking at what's going on today in terms of the rapid deployment, I would say, of litigation, legislation, and just what's happening overall in the industry. A former colleague of mine once said, it's the new abnormal for where we are, right? We're seeing these, vehicle prices reaching record highs. We're seeing those prices continue to escalate. We're all very aware of the supply chain issues and inflation. The used vehicle prices increased in August, even though there was a slight little decline year over year. That consumer sentiment that's decreasing from previous months due to the inflation, even though we've seen some, gas prices come down, it's certainly gobbled up in the form of other forms of expense for the average consumer throughout the country. Industry-wide, Allied, we do a lot with delinquencies, with, tracking of optional ancillary. Insurance, not only just the products themselves, we also do some tracking when it comes to insurance on the collateral, vehicle collateral. And we're seeing some of those normalizations occurring with delinquencies, and we see some industry indicators that they're predicted to reach pre-pandemic levels now within the next 12 months. Auto defaults are slowly rising. And as we continue to see the Fed's aggressive rate hike environment that we're in, many are looking at a potential recession expected as prices remain high and consumer sentiment remains low in terms of the industry. All of this, to me, kind of indicates, as we look at this environment on the next slide there, where the product refund liability is only going to continue to grow, right? We've got a lot of link here in terms of some of the recent activity that we've seen from the FTC. We know the comment period for some of this proposed rulemaking, Stephen, is rapidly closing. There was no extension to that. And really, when we look at some of these issues when it comes to the voluntary protection products, or VPP for short, there is a lot to unpack here. And just in conclusion here, before I turn it over to some comments from Stephen and then you, Robert, when you consider the industry and what the average auto loan looks like for a consumer today at those rapidly escalated prices, including higher prices of the products that the dealers are selling, the VPPs, these voluntary protection products, and the increase in loan terms. We're seeing credit unions going out to 84, 96 months. Traditional auto finance, maybe still in that 72-month range, and some of the big national banks kind of holding more closely to more of a 60 to 72-month loan term. But when we're starting to see things out at 84 months or 96 months, and you consider the amortization schedule of those products built into that financed auto loan, Stephen, help me out here, but what would you say that liability is going to be looking like in the next 4 to 5 years on deals done today?
Yeah, I think we're on an upward trajectory with that, Peter. I think a lot of the points you make are directly on point. And this particular article, when I read this article, it feels a little bit like a war when you start to look at the numbers that are starting to stack up out in California with some of these class actions. We recently had a settlement approved for Toyota with respect to gap waiver that was $78 million. I think we all saw the Wells Fargo settlement earlier. There was a Capital One motion to dismiss that was denied. Frankly, a lot of the arguments that you would traditionally make in connection with these VPP products relate to the fact that this is not the lender's product, and I think that that's been put to rest, certainly in California, in connection with gap waiver. And I think as we look out at what we're doing with the lenders that we work with, I think there is a fear that it might get more broad than gap waiver. When you look at the FTC's rules that they've proposed, it's very clear that a lot of the activities surrounding voluntary protection products, they are wanting to deem unfair or deceptive. And so I think for our lenders, what we look at is okay, well, if the FTC has deemed this an unfair or deceptive act or practice, could it be that a lender is being deemed to provide substantial assistance to the dealer through advancing funds on that? So as we look at the attachment rate to loans, historically, I think Robert and Peter, you can probably echo this. Historically, I think we've seen around 60% of the financed deals have products on them. And then out of those deals, 1.5 products on average is what you see per each financed vehicle. So there are a lot of these products that are being financed. And we do think that the regulator, and probably worse, the class action focus is starting to be placed on products. I think there's a hyper focus on gap waiver. And I know we're going to talk a lot about refunds because I think that's where the heightened risk is with respect to gap waiver, but I think it extends to other products as well, especially when we're talking about repossessions. So there's a lot to be focused on, and making sure that we're not losing sight on these issues as they continue to pop up. So I'll pause there and turn it over to Robert, but I think you're 100% correct, Peter. There's a lot to be focused on, and there are some concerning trends that we're seeing on the horizon.
Yeah, I couldn't agree more, Stephen and Peter. I think you're spot on with that assessment. I think if I take a look 3-4 years ago, I know we always presented Cox Automotive kind of a heat map of the states that have legislation or kind of looking at, where the refunds and VPP products need to be canceled in and timing around it. There was a handful of states 3-4 years ago. I think if we brought up that map today, you'd almost see something in every state, with some type of legislation or discussion around VPP products and cancellations and when refunds need to occur and go back to the consumer.
Yeah, great point there, Robert. And I know we had talked before from a dealer track perspective, and we can jump ahead to the next slide too, and just the amount of products that you see financed between the dealer and the lender. And it was amazing, I think, and Robert, just a quick follow-up for you on that. Didn't really see much change during the pandemic, but I don't want to misspeak there, Robert, or misrepresent. But it does seem like there's always additional products that are being cross-sold.
For sure. I think you're seeing an onus with limited, inventory at these dealerships. Some of the Cox Automotive studies, the amount of, aftermarket products are now being purchased. That's a huge hot item for our dealer network, and a way for them to, obviously gain not only the new consumer for a new vehicle, but also the additional products and opportunity for additional funds and to make money at the dealership has been a hot button with all the dealerships in our network.
You got it, Robert. And as we progress through even this next slide and even the next one, Stephen, I want to kind of come back to you as we set our sights on California. But you had referenced something, Stephen, that I think should be emphasized and is a particular area of focus when it comes to unfair practices, if you will, in the industry, right? And that FTC proposed rule in conjunction with the CFPB and some of their UDAP findings as of late, and certainly not one, not two, but 3 supervisory highlights going back, all focusing on this issue from collections, as you had indicated, to where we are now with early loan pays and the intense scrutiny on gap waivers. If you wouldn't mind, Stephen, shed some light just on this. I'll almost call it a an alignment between agencies that are coming into some really laser focused legislation when it comes to the servicing of these gap waivers. And obviously, case in point, as we see on the screen here, California Assembly Bill 2311, which is now law.
Yeah, I mean, from a federal perspective, I think most lenders and most in the ancillary product industry, or voluntary protection product industry rather, I think that the concerns were there when Chopra got tapped to lead the CFPB, obviously coming from the FTC, knowing that when Dodd-Frank was enacted by Congress, there was a carve out for dealers. And really the dealer is overseen by the FTC when it comes to these types of investigations or rulemaking. Having Chopra come from the FTC, I think everybody saw the writing on the wall. Frankly, I think it took a little bit longer than I would have anticipated to see the FTC actually take some action. Those of you that follow the FTC, I'm sure, saw the Napleton action that was focused on VPPs. So we do think that the FTC and the CFPB are going to be kind of walking lockstep when it comes to federal oversight. If I'm reading tea leaves, I'm thinking that this FTC rule could have potentially been drafted by Chopra before he left the FTC and left on a table somewhere for someone to pick up and run with. I do think that to this day, within the halls of the CFPB, there's probably some disgruntled folks that they lost the ability to directly oversee dealers, but the FTC is picking up the slack there. From a state perspective, you're exactly right, Peter. I mean, we see state legislation that is popping all across the country that is affecting these particular products. And one of the things that, we'll talk about today as we dig in a little more detail is this California bill that was signed into law by the governor, goes into effect next year. there are quite a few provisions in here that I think should give serious pause to the lenders that are joining us, that are financing loans in the state of California, indirect loans, I should say. It's not entirely clear that direct loans would be brought into the scope of this legislation, but there are provisions in that legislation that is signed into law that make the administrator of a gap waiver the agent of the assignee lender or the holder of the retail installment contract. There are quite a few provisions in there that lenders need to be paying close attention to, and I know we're going to talk about it today, but I think one of the important things that we stress to the lenders that we work with is to know what you're financing. And if you know what you're financing, half, a third, you've at least made a dent in the battle ahead of you, because then you are able to control the product that is potentially having you called to the carpet during an examination. So for the foreseeable future, we don't see this slowing down. Typically, California is the bellwether for blue states when it comes to legislation. So we could see something like California Assembly Bill 2311 pop in other states. We know Colorado has been taking a very proactive approach to enforcement when it comes to gap waiver. The Attorney General there, I think, may have been in a little bit of an agreement or had conversations with the California Attorney General. We expect legislation in 2023 in Colorado specific to gap waiver. So we just don't see it slowing down for the foreseeable future, whether it be through legislation, regulatory enforcement actions, or perhaps worse, the trial bar in class actions. I think some of the class action attorneys out there have found what we refer to down here in Florida as a honey hole when we're out fishing. And for a class action attorney or a plaintiff's attorney, that means attorney's fees for them. And so it's a little bit of a rinse and repeat when it comes to some of the litigation we're seeing in the claims that are being levied.
Yeah, great point on that, Stephen. I mean, this next slide kind of highlights, I think, some of the things you referenced relative to where has this been coming from and where is it going, and that concentration of activity into 2022 and certainly beyond. If I recall too, and the state of Texas looked at trying to bring some clarity to the refundability of these products and who owns that relative to dealerships versus the auto loan servicer. And a couple of times over the last couple of years that was brought up, and time again. And I know we've talked about this, Stephen, but Robert, I'd love your thoughts on this too when it comes to the lender being the responsible party, whether it's through assignment, whether it's simply through the servicing of that auto loan, when it comes to repossessions, when it comes to early loan pays and the absolute necessity. Stephen, as you referenced earlier, but Robert, just wanted to get your quick thoughts on this relative to know what you fund, right? In terms of where this industry is going and who. And here we are again, looking at the lender being square in the bullseyes from states to the federal level. But Robert, certainly want to give you a chance to chime in on all the stuff we're seeing too.
Yeah, for sure. I think we see it. That's probably the biggest confusion I see in the marketplace with the lenders we work with today is who the onus is on for the cancellation. I was just with a few lenders last week to give you some examples. And a lot of the lenders I speak with, they're not even sure what ancillary products are purchased part of their financing agreements. So it was eye-opening to me. And I think now they're starting to scramble to completely understand, some of these legislations and, compliance things that are out there on what needs to be done because they're just not tracking it today. So I think Peter and Stephen both said it. You need to have a strong mechanism in place and you'll be well ahead of the game if you are tracking those aftermarket products that are being purchased. I think the second thing I'm hearing from a lot of lenders I'm speaking with is they don't believe, they're the ones responsible for the cancellation. A lot of them are telling their members or consumers to go to the dealership that you purchased it from. They'll start the cancellation process. Or, we'll send out a letter when we release a title that may have some information on there that, hey, go cancel a product if you did purchase at the time of the agreement. So I think that's the biggest thing I'm seeing across the board with all of our Cox Automotive lenders is just understanding who's responsible for what areas of the cancellation.
Yeah, great point there, Robert. We can head a next slide that really brings this to our first, poll question really for our audience today. I know Nick will compile these results, but really, when you look at who has that responsibility, Robert, just as you said, we've got A, the dealer, B, the financer, C, the consumer, D, my state regulator determining that, and then of course, E, all of the above. But as folks start chiming in with responses here, Robert, you raise a very good point. You've got a lot of hands in the pot. You've got money that is in different pots relative to the refundability and the portion of those refunds and how they need to be tracked, how they need to be reconciled, and ultimately, to your point, Robert, how they need to get back to the consumer, right? Like there's the heavy lift. And when you think of, whether it's state law bringing this into fruition or federal oversight, it is your observations from some of the lenders you were just talking to, Robert, I think are spot on. And as we see the results coming in here, right now we're looking at about 55% say that the financer is responsible. 18% are saying that the state regulator determines that, and 27% are saying all of the above, right? And Stephen, just turning over to you too. I mean, sometimes we hear a little bit about what the responsibility of the lender is in this complex process, and Robert, you said it best too. You send out a letter, right? And what are the challenges associated with the follow-up to those letters? Again, in order to ensure that the actual refund makes it back to the consumer, this slide kind of highlights what some of those aftermarket challenges are. But Stephen, would love your thoughts and everything relative to what we're seeing relative to this first poll question and that ever slippery area of responsibility with all of the parties involved with this.
Yeah, I mean, I wish it was an easy answer, right? So I think it can differ depending on what we're talking about. I mean, when we look at the CFPB supervisory highlights, when it comes to repossessions, clearly the CFPB has signaled during examinations that, it is on the lender to figure out the refunds and net them out of any outstanding balance before they go off collecting a deficiency balance in the event of a repossession. And so that would apply across all products. Look at the supervisory highlights, and that makes it very clear that that's the CFPB's opinion. Early payoffs, I certainly think that the litigation and quite a few state laws, to Robert's point earlier, would say that it is the lender's responsibility. I think irrespective of what a state law says, the litigation that we're seeing is making it very clear that, at least for a gap waiver, that most would consider it to be the lender's responsibility. If we think about how a gap waiver works, it is a product that amends the finance agreement. And so the quote unquote obligor, the party obligated to make good on the promises within the gap waiver, is the lender. There is an administrator involved. As I mentioned before, the California legislation is a little bit scary because it makes the administrator the lender's agent for purposes of the finance agreement. So, it is sadly not a simple answer to the question, but I think based on what we've seen out there, the best course of action is to consider it something that the lender is facilitating and ensuring is happening, because I think given the focus that the CFPB has put on aftermarket cancellations and refunds, it is not wise to just assume that it is someone else's responsibility. We hear a lot of folks saying that, we send them back to the dealer. The dealer sold the product to them. Well, I can tell you that, when you talk to a CFPB examiner, they don't really like that. The consumer may have had a bad experience at the dealer, and so they need other options to be able to cancel. But again, when it comes to repossession, it is crystal clear that the CFPB's perspective is that the lender needs to be figuring out what those refunds are, so the consumer is not being chased by a debt collector for an inflated balance on optional products that are cancelable.
Tell you what, Stephen, you just raised a great point there. When it comes to debt collection, another high priority of our regulatory officials. And we've even seen some consent orders, at least recently, relative to the inaccuracy of some credit bureau reporting. And even if a product refund is not explicitly stated as part of that consent order, I think between that product refund liability and all of the servicing requirements that go into this, especially on the collection side, as you said, but debt collection, right? I mean, that's right up there near the top of the list for some of the things we're seeing from the federal oversights incumbent within this process. And that product refund liability to me would be could be a very significant portion of inaccurate credit bureau reporting, especially when you get into the repossession, first and third party collections. And anyway, you raised a great point there, Stephen, that just made me think of how debt collection is a continued topic beyond refund liability that we continue to see manifest itself in the headlines. But importantly, how to recognize how product refund liability can actually be part of that in what's reported out to the credit bureaus. Pause there for some of your thoughts, Stephen, and then you as well, Robert.
I couldn't agree more. Debt collection is obviously in the crosshairs and has been since day one of the CFPB and other state and federal regulators. And so making sure that you're not chasing a consumer for a balance that could otherwise be paid down through a cancelable product, whether historically or not a lender has viewed that as their responsibility. Clearly, some of these regulators view it as the lender's responsibility.
100%. And I think we do see some of that with the lenders we work with today for, repossessions, total loss. They're in there looking for ways to possibly cancel out a product to tie it back a deficiency balance. But that kind of brings me to the next point, Peter, which is, coming from the titling space and seeing the number of titles that are released on a monthly basis, we know that over 50% of loans are paid off early. Right. So with that, we know that obviously a lot of products, don't get to the fruition of the entire loan, and they'll also have to be canceled as part of the aftermarket product cancellation process. What are lenders putting in place for that? I think that's one of the biggest gray areas I see across the board is, a lot of lenders didn't feel like they're responsible if a loan terminates early, that actually they have to go in and cancel out the product as well, or even alert their consumer or their member that the cancellation needs to occur because it didn't reach the fruition of the end of the loan. So what are your thoughts on that, Peter or Stephen?
Yeah, I couldn't agree there more either, Robert. I mean, we talk about how many loans make it to maturity, and it's very little. And this slide, I think, starts to speak to that complexity when it's incumbent upon the lender to perform, to make or cause to be made that refund, and where that responsibility, execution, formulas, UDAP violations, all this stuff on the slide talk about. And it's so interesting, Robert, too. I love what you said there, diminuous refund amounts. And Stephen, I'll kick this over to you, but there's some states that will, within statutes, say if the refund is going to be less than a diminuous amount, I'm talking like $5, it doesn't need to be processed. But when we again start to see originations creeping in excess of 72 months, with Gap being sold for $1,000, that refund, even at month 67 or 69, is likely going to be more than $5, again, depending on refunding methodologies. But we do get that question quite a bit from the industry. It's like, wait a second, do we really need to be concerned about something that pays off a month or two prior to maturity? And the way we read a lot of these statutes, and again, looking for your thoughts here, Stephen, but, I always say that any event that causes that retail installment sales contract to terminate early, needs to be considered. But yeah, Stephen, why don't you, if you can, give us kind of your quick assessment too on when those de minimis amounts would indicate or predicate that no action needs to be required.
Yeah, so you're right. I mean, there are states that have provisions in them that would say, under a certain dollar amount, the refund doesn't need to be processed. Those are very few and far between. And so I think when you look at what most states and what most contracts have in them, there's typically a pro rata refund. So the last month is worth as much as the first month, right? Now, I know there's some rule of 78 calculation methods that are used, but by and large, these products are typically driven by a pro rata refund after the full refund period. So that last month is going to be just as much as the first month. And so you might talk about small dollars, but I know, Peter, you and I have talked about this. If you look at all the consumers in a state, it starts to add up. And I think one of the things that we're starting to see a tip of the iceberg on, based on some of the comments we've seen in California, is there's this little known or little talked about rule in most states, and it's a big legal word that I'll use. It's called a sheetment. And typically there are laws in almost every state in the country, if not every state in the country, that says, hey, if a consumer is owed something and the consumer is not paid that amount or doesn't collect it within a certain period of time, that money goes into this unclaimed property fund within a state. That's all fine and well, but the problem with that is there are outfits in the United States that really go chase that money for states and then take what is really kind of a contingency fee or success fee when they collect those dollars for the state. And so I do believe that these refunds and the use of the word escheatment that we've seen in California in some of their early comments in connection with this legislation, hopefully don't show where we're headed here. But if that is the case, I'm worried that these outfits that have made a living by going out and collecting this money that should escheat to the state and then taking a cut of what they collect, this is just going to be something that they're going to actively pursue and bring to the state's attention because it creates money for those outfits.
Mm-hmm.
So, yeah, I mean, the amount, the ability to make sure that it's being provided to the consumer to avoid that type of a scenario is significant. And this particular side, I think, is really illustrative of all the issues that lenders face. And I think one of the things that we talk to our lenders a lot about is, one of the things that they have to realize is we get it. Dealers sell these products. They need to sell these products. These products can be valuable if sold properly. But at the end of the day, it is a privilege, not a right, to have these products financed by the lenders. And so lenders, I think now more sadly, as a result of some of this activity, are waking up more and more to the fact that, hey, if we're going to advance funds on these, there's some things that we need to make sure that we set as the guidelines for the types of products we want to finance. And if they can do that and drive that relationship with the product companies, I think it's going to benefit the consumer, which in turn will benefit the dealer, will also benefit the product company, and then of course the lender as well. So trying to capture that and driving that relationship directly with the product company, not doing it through the dealer because that creates friction with the dealer. I think that's the key here, because it helps us to be able to address all of these complexity issues when you have that relationship and you're able to speak directly with the product company rather than through the dealer.
Yeah, that's a great point, Stephen. Yeah, the complexity almost seems onion-like, layer upon layer. And I think just in terms of this next slide, we're talking about that simplification of the process and how to improve. I know we've said this kind of repeatedly throughout our time together here today, but it starts with knowing what you're financing and knowing what your obligations are, and I'll kick this one back to Robert real quick, but when we think of a total loss and there's a gap policy in place and the refund of that gap policy yields a better amount, a better dollar amount for the impacted consumer versus the actual gap claim, given the fact that Automobiles are an appreciating asset class in today's world. What do, right? Do you file the gap claim? And if that amount is smaller than the actual refund for the gap, what's the correct course of action in an environment like that? And depending on which one you take, would a regulator look at that as a UDAP violation if there was a result that somehow lessened the benefit to the consumer, literally the difference between the refund amount and a claim amount in gap? But Robert, with the title work you do, I know that one's near and dear to your hearts as well.
No doubt about it, right? From a total loss perspective, making sure that that title gets out the door, the negotiation from a payoff quote matches to what the actual financial terms are behind the scenes. There's a lot of back and forth that occurs. And it's funny, talking with the lenders, they kind of throw their hands up a little bit because they're saying to me, we don't have a great tracking mechanism in place to know what aftermarket products are purchased. There's over 50 states with different timing on when the refund is due back to the consumer, right? There's over 550 aftermarket providers that are out there. So how am I going to know who to call, when to call? Is it an email? Is it a fax? What direct number to get that exact cancellation quote? And then it ties back to the dealerships, right? With over 23,000 dealerships and working with the dealerships, knowing that the last thing a dealership really wants to do, right, is to go in and cancel out a product. That's not what they're looking to do. So with all those challenges for lenders, they're all looking for ways to kind of streamline that process.
Yeah, well said, Robert. Yeah, I think we can hit the next slide here as we approach our next question. If an audit were to happen today, what will your audit results show as a lender? Will there be some contract status tracking issues? In other words, knowing what you're financing. What about the accuracy of those refund calculations? The timeliness of those refund cycle times? We know in some state statutes that's clearly called out. 60 days, I want to say, Stephen, to California Assembly Bill 2311, as originally written, was looking for that to be done in something like 25 days. I think the law as signed going into effect Jan 1, 2023 is putting it back at 60 days. Historical reconciliations, what's been done in the past, and has that been accurate? And then, of course, we always like to have the all of the above, the proverbial all of the above for if you were audited today, what are the things that are going to be scrutinized, looked at, perhaps given an assessment for needs improvement? And as these results are coming in, I'm seeing this right now probably at like 33% accurate refund calculations, 25% now. Historical reconciliations coming in at 25%, all of the above showing up at about 50% right now. But Stephen, give us a little perspective from your extensive work you've done helping some of our lenders through these routine or otherwise audits, and what we're seeing here in terms of where some of the greatest opportunity for improvement resides.
Sure. So I would say these, all of the above at 50% is pretty impressive. I think the lenders that we speak with very frequently are always telling us we don't know what the cancellation fees are. And, it's usually focused on gap waiver, but it applies to all the products. So one of the things we try to do at F&I Sentinel is, as you know, Peter and Robert, we try to kind of monitor the front end and make sure that the lender has a good repository of all the forms that are approved for funding. So then on the back end, on the resolution of the products, we can hand those off to you guys at Allied and at Cox to say, okay, we know what to do now. We have the products. We know exactly what the calculation is. But my sense is, and from talking to the lenders that we've worked with over the years, is that most of them will calculate a pro rata refund, and then the lender, quote unquote, eats the cancellation fee because they don't know when it's assessed, when it's not assessed. And so to me, that is a very, very significant problem that needs to be addressed, just to make sure they know that they're charging the right amount, or that they're not eating that on their own profit and loss statement. So I think that's an important one. The tracking for the lenders that we've worked with that have undergone regulatory examinations, they have been asked to produce copies of contracts that they've funded. Thankfully, at least the ones that we've worked with, we've been able to, through our relationships, through our software that we use, been able to get legacy contracts that have been funded. And then since implementation of the solution that we worked with the lenders on, they have copies of those documents that they can provide to the regulators. But having that audit trail, knowing what you're financing, it's half the battle to ensure that you can resolve them on the back end and help provide you guys at Allied, Cox, F&I Express the solutions, the information in order to be able to help the resolution when it comes to an early payoff or a cancellation.
Yeah, you got it, Stephen. I love that collaboration and integration too, because, and Robert, I'll turn it over to you here. The combined strength of our partnerships, what we can do to help lenders and vice versa, learn as well. We have had some lenders, kind of go through examinations, utilize some of our services when it comes to product refund liability, have a repeat examination and come out in a more favorable position, right? And those kind of peer-to-peer, lender-to-lender discussions, we definitely want to encourage through the great folks like we have here at Cherokee Media, and some of the upcoming in-person live events that we'll soon be attending again as well. So lots to look forward here to make these conversations live and in person. And Robert, I just wanted to make sure I could, get some good feedback from you too. I mean, just in the technology alone, when you combine that horsepower with the people power, what that leads to in terms of I will call reducing the complexity of those, the product refund liability, the expeditious accelerated title solution, et cetera. Just, your thoughts on how we best solve those lender pain points.
Yeah, I think it really ties to automation, right? Streamlining a very manual process. So, once we do have that, correct information on the aftermarket provider, obtaining that exact quote, I think we talked about it throughout this presentation for repossessions, total loss, early payment, payoffs, making sure you have the correct and appropriate amount. With over 550 providers, that's not an easy task. We have an integrated solution. We have a lot of APIs in place where we're able to instantaneously pull out what that exact cancellation is amount for that aftermarket product that's looking to be canceled. We also have the availability with touching the dealers. So with the dealership network, we're sending out cancellation notices, not only like we talked about with the aftermarket provider, but we're also letting the dealerships know simultaneously that cancellation has occurred. Now, a lot of that's being manually done or not done at all with the lenders I'm speaking with today, but with our automated solution, this now can be a streamlined process for most of our lenders.
That's a great point, Robert. And I really think that kind of brings us home for the final slide on the next one here when we start talking about, what that means for the lenders, that proactive moving forward approach. And certainly, I like the graphic here of, kind of becoming a superhero when it comes to what's going on in the industry. You can obviously say, Stephen, there's been a lot of precedent set for the attention around all of this, but how we pivot and how we can move forward on this proactively, learning from each other, discussions like this. And like I said, having a lot of these discussions in person over the next couple of months, as we get into the fall circuit here, but really identifying, we hear this every time in routine exams or other, or routine or otherwise, as I always like to say, but having a documented process to handle these things, right? The exceptions, the happy paths, what happens when you don't necessarily hear back on a refund request, what are those timeframes to proactively move something forward? Yeah, there's going to be times a lender has to maybe eat some of those costs, but always keeping that consumer front and center, the borrower front and center. Sometimes, yeah, the difference between the state and the federal regulators can kind of go away if you're just keeping that consumer front and center in your proactive approach moving forward. But Stephen, any concluding thoughts? I know we've got about 10 minutes, maybe, Nick, as we wrap up here on this slide, and just wanted to give Stephen a chance to respond on some of these proactive measures lenders can take.
Sure. Yeah, and I know we want to leave a few minutes for questions, so I won't try to take up all the air. But I would say doing nothing is no longer sustainable. I think we've seen that from the numbers when it comes to some of the lawsuits and the regulatory statements that are out there for public consumption. So being proactive is critical. This slide highlights the things folks ought to be doing. Taking control of the products you're financing. It may be that when you actually start to look at your portfolio and see what you are financing and advancing funds on, that you decide not every product is for you as a lender. Again, that FTC rule, they are looking to determine whether or not the products that a consumer purchases provide value to the consumer. And they're making comments like, is it duplicative of limited warranties that might come with a new vehicle? And so when we see things like that that are labeled as unfair or deceptive under the FTC's oversight, I get very concerned that that could bleed over to the CFPB, where advancing funds will be deemed as providing substantial assistance to some of that UDAP activity that the FTC is deeming to be unfair or deceptive. And so if you're doing all that and you're being proactive and you know what you're financing, the last box here, coming up with a product refund strategy, it puts you in control of that, right? And it allows, if you're, and I know we always talk about this, Peter, but if folks try to do it in-house, that it allows you to take control of that. If they've made the decision to outsource it to groups like Allied and Cox, it gives you guys the tools to help you make them more efficient and effective. So I think that the key to this is being proactive and doing something. I think doing nothing is just not sustainable any longer, because that seems to have been the mindset, for the last maybe 4 or 5 years for a lot of lenders, not all lenders, but I just think it's not sustainable going forward.
Yeah, well said, Stephen. And Robert, I'd love your closing thoughts on this too. And I think our great folks at Cherokee Media, Nick, will probably open up some Q&A for those folks that may have some additional questions. But when it comes to the real talk on these refunds, I mean, my goodness, Robert, we've had many conversations about this, where you have states that indicate the borrower needs to take some action, whether it's considered consumer financial literacy or not. I think Stephen raised a great point there, Robert, relative to inaction is almost punitive in today's world. So love your closing thoughts there.
Yeah,
Robert.
I agree. And I think do right by your customer, right? Your consumers do that refund. Don't make them have to track it down on their own. Don't make them have to guess on how this process works. There's solutions in the marketplace that will allow the cancellation to occur, and make sure those refunds are, get back to that consumer in a timely fashion, as well as, from a lender perspective, keeping your dealers happy. Dealers now won't have to do some of this upfront work or these cancellations if you put a streamlined process in place that does that cancellation on their behalf. So, like I said, do right by your consumer, and I think, like we'd all agree, they'll continue to come back to you for additional business and financial needs.
Couldn't have said it better, Robert. Excuse me. Yeah, that inaction is no longer acceptable. I think that is a real talk on refunds there. So I want to thank both of you, Robert and Stephen, for your time and consideration today. Nick, if there are time, I think we have a little bit of time for any Q&A that may come through. We definitely wanted to leave some time for that at the end. We appreciate your consideration in this matter, and let us know if there's any chats or questions coming through.
Absolutely. Wonderful presentation, gentlemen. Certainly complex situation and protocols to say the least. So if you have any questions for our special guests, experts who are part of today's webinar titled Real Talk on Refunds, Elevating Your Aftermarket Servicing with Peter Kroll of Allied Solutions, Robert Christini of Cox Automotive, and Stephen McDaniel of F&I Sentinel, just use the chat function here on the Zoom platform, and we'll use the last few moments here that we have during our time together. And gentlemen, one question will tee up here, and forgive me if it's one that you've probably heard a time or two as you've interacted with your clients and other finance companies, but hypothetical here, saying that finance companies positioned itself that they report their cancellations to the product provider, and doesn't that satisfy our compliance or the extent of our obligation? If you could just revisit that topic of reporting the cancellation to the product provider, and sort of that is all that needs to be done. How much or how little or how short of the burden does that go?
Yeah, great question, Nick. Yeah, it's a start, right? And a start is better than not doing anything, to Stephen's point, but it is not the conclusion, right? We do hear this quite often, hey, wait a second, I need to cause the refund to be made, make the refund or cause the refund to be made. Well, the regulators are simply going to ask, did the consumer get their money? Was it timely and accurate, right? So that is a great start. Applaud lenders who are doing that today to try to initiate that refund, but it's the follow through. And sometimes beyond technology, having a team in place that is following through with those dealers, reconciling that refund amount, and ensuring that it gets to the hands of the borrower. That to me is a great start, but not the all end all, if you will, when it comes to why that's not sufficient in today's world. But Stephen, Robert, anything to add to that?
I think that's well said, Peter. I mean, something's better than nothing, right? I mean, I think getting that cancellation started is a good starting point, but there's many other activities that need to go along to make sure that consumer receives that refund. And this, specifically with some of these states and legislation that's out there, in a timely fashion, right? Making sure that the dealer piece is also coming back to the consumer as well. So there's a number of different areas, makes it complex. But all of them have to be completed to make sure everything gets finalized in the end.
Yeah, Robert, you're right there. I mean, there are timelines in certain states as to when the refund needs to get back into the consumer hand. If we're talking about gap waiver, that is then the obligation of the lender. The penalty is going to come back on the lender. And then, of course, I know I sound a little like a broken record, but it was, eye-opening when you see in the repossession world, just notifying the consumer that they may have a product that might be cancelable, and to contact the provider, or contacting the provider and letting them know there's a cancellation, figuring out what that refund is and applying it to that outstanding balance, critical. So I think it's a start, to echo Peter and Robert's comments, but certainly going a step further, I think, is warranted in this day and age.
Closing moments here during our webinar, brought to you by our friends at Allied Solutions. Real talk on refunds, elevating your aftermarket servicing. And gentlemen, to round us out, perhaps, Stephen, we continue with you, and then Robert and Peter to round us out. If you could just elaborate again on the significance of the measure that's percolating in California, AB 2311. Again, the significance of this bill to creditors, and perhaps it's too much to speculate, but just how might it be a pathway for other states to create similar measures? Again, let's start with you, Stephen, about what is happening in California, and then any other thoughts from Robert and Peter.
Yeah, so we believe California is really Colorado bleeding over. Colorado's Attorney General took action against several credit unions specifically, although they took action against other lenders as well. And our understanding is that Colorado Attorney General, held a call with as many state attorneys general that would participate, and started to talk about some of the findings that the Colorado Attorney General was having, which led to the California Attorney General pursuing AB 2311. It is daunting for lenders. I mean, it makes very clear that the assignee lender on an indirect auto finance transaction is the contracting party under a gap waiver. It does, as I've mentioned before, make the administrator of the gap waiver the agent of the lender. There are specific disclosures that are required within a gap waiver, which will in turn result in violations by the assignee lender if those disclosures are not contained within the gap waiver. There are prohibitions on when a gap waiver may be sold. Harkens back to the CFPB consent order with Santander when it was speaking about LTV caps that exist gap waivers in the market. So there is a lot to pay attention to. Payoff quotes, need to reference specific items with respect to refunds. It is one that any lender that is active in California should read and should be taking proactive steps to ensure that they are not funding waivers that do not comply with the provisions of that legislation. It's a daunting task. It's one that can be tackled, but this is one you cannot put your head in the sand on.
Well said, Stephen. Thank you. Robert, to add to that.
Yeah, I think the big thing here, this isn't going away, right? I think we're seeing a lot of press on this. We've been to a lot of industry events this year where you've seen presentations on, CFPB and aftermarket products and cancellations that need to occur. I think California is the starting point here, and I think you're going to quickly see this start to expand. Some of our lender partners that we do business with today are already putting plans in place, and states they weren't doing cancellations in before, they're now starting to look to expand to offer cancellations in all states in all scenarios. So again, I don't see this going away, and I hope our lender partners are looking for ways to put a strong process in place, and not doing a lot of this manual effort.
Indeed. Peter Crawl with Allied Solutions, that the last word for our session today.
Yeah, in the 13 seconds we have remaining, Nick, what they said, right? When I was a kid, I wanted trends came out of California, right? Vans shoes and a bunch of other things. And everyone wanted, Van Halen, you want to be like California. Now that trend is almost like, whoa, hey, if that's going to become precedent for the rest of the country, or other states will follow, to Stephen and Robert's points. Inaction is action, and it ain't the right kind of action. So thanks so much, Nick. Really appreciate you hosting today.
Absolutely. Astute points to round us out. Again, our special guests for today's webinar, again, titled Real Talk on Refunds, Elevating Your Aftermarket Servicing, has included Peter Crawl, the Vice President of the National Market Group at Allied Solutions, Robert Christini, the Senior Director of Lender Solution Sales at Cox Automotive, and Stephen McDaniel, co-founder and Chief Executive Officer of F&I Sentinel. And there on the screen is a path to more resources offered by our friends at Allied Solutions via social media and their website at alliedsolutions.net. Again, gentlemen, thank you so much for sharing such great information. Again, as you've articulated, a matter that's not going away. Gentlemen, thank you again.
Thank you. Appreciate it.
Appreciate it, Nick.
And on behalf of all of us at Cherokee Media Group, my name is Nick Zulovich. We thank you for joining us, and we look forward to having you again next time.